For now, I think, yes. Don, you're up. Good. Well, good morning, ladies and gentlemen. My name is David Daubney. I'm a former chair of the Justice Committee in the House of Commons. And after I left Parliament in 1988, I've spent most of my career with the Department of Justice, heading up the sentencing work of the department until I retired last year. I'm also a member of the Smart Justice Network, which is the sponsor of this meeting, and as are most of the others here. We're fortunate to have two judges with us, retired Senior Regional Justice James Chadwick of the Ontario Superior Court. He's right here. Next to him is former Chief Judge Barry Stewart of the Yukon Territorial Court. We also are pleased to have Steve Sullivan, the former federal ombudsman for victims, and Don Bayne, who is a prominent Ottawa criminal lawyer who is representing the Canadian Criminal Lawyers Association. We've titled this conference C-10 and its consequences for a fair and effective criminal justice system. And I'm just going to begin by outlining what I think is the litany of consequences, negative consequences for the justice system. And I think this has been borne out by the testimony both before Christmas in the House of Commons and recently, it's still ongoing, as you know, in fact, in the Senate committee. Essentially, the bottom line on this, in my view, is the cumulative impact of C-10 and the predecessor criminal justice legislation that's been introduced since 2006, and the hints we've heard about what is coming from the Justice Minister, means that pretty soon we will no longer have a fair and effective criminal justice system in this country. In my view, and the view of the network, the proliferation of mandatory minimum sentences, the virtual elimination of conditional sentences of imprisonment, which has been a highly successful alternative to incarceration, the de-emphasis on rehabilitation, particularly in the youth system, what I really think is the mean-spirited changes to the correctional system, particularly, for example, with respect to pardons, which will be very difficult for people to get and very expensive for former offenders to get. The changes to the parole system, which will make conditional release harder to obtain. The basic, what I call almost intimidation of parole board members to be tougher. The grant rate for parole is down substantially already. All this is translating into a burgeoning prison population, both remanded, those not yet found guilty, and sentenced. And it's happening all through the system. The system, we have to remember, and the federal government seems to forget this quite often, a lot of it plays out at the provincial and territorial level. And they have to carry the burden of the legislation coming from Ottawa. And they're not getting, apparently, any money to do that. That's a real serious concern, as you know, to a number of provinces, particularly Ontario and Quebec, and certainly the smaller provinces. It's the nature of our division of powers in Canada, and it doesn't work in the criminal justice area very well. I think the impact on courts, perhaps the judges will speak more to that, will be severe. The number of accused is going to go up. It's going to be difficult for courts to deal with that increased workload. The risk of stays of prosecutions occurring, like has happened with the Askov situation in this province, is, I think, very high. We know that we have a disproportionate number of Aboriginal Canadians in our prisons, 22% in the federal system. They only make up 4% of our population. In places like Western Canada, they're 80% or more of our prisoners at the provincial level. So we're going to have also, I think this is important for people to know, more offenders with mental health issues which have led them into crime. A lot of fetal alcohol spectrum disorder, particularly young people, particularly Native people, which means that they have very little control and will need lifetime supervision, but that supervision should occur in the community, not in jail for people that really can't have the intent to commit crime. So we have the cost issues, which are huge and which I think the government has, at the federal level, has almost been willfully blind to the provincial costs. And that is all leading to, in a time of economic restraint, to a strange juxtaposition, not only in a time of restraint, but in a time of continued decreases in the criminal rate, going on for 20 years. And some of the drops are extremely high, in the 30% range. And that's all being ignored. I think fear is at the basis of much of the government's work here. And what it's going to do, unfortunately, is make Canadians, I think, more fearful and less safe. And in that regard, and it's all being done in the name of victims, giving victims a greater role, protecting victims. And in that regard, I'm going to ask Steve Sullivan, the victim expert, to explain his views on that.
I will be very brief. Just to say that obviously we have concerns about the bill. As David mentions, being sold as being a bill that's going to benefit victims of crime. In fact, concern that's going to be the opposite. When Crowns are saying that they are not going to have enough time to prepare cases, that means they'll accept more plea bargains that they normally wouldn't do. They'll have to stay more charges. That's not an agenda that benefits victims of crimes who turn to the system for justice. Nothing in the bill will assist a woman who is deciding whether or not she's going to stay in an abusive relationship or potentially live in poverty because there's no safe place to live. It will not help a woman who may be one of the very few who's been sexually assaulted and actually reports to police and rarely will actually see her case go to court. There's nothing in this bill that will affect any of those victims. And finally, the bill is being sold as tough on sex offenders. Unfortunately, the government with this bill is going to spend 10 times more money on dealing with sex offenders than they are dealing with children in building child advocacy centers. We believe that a lot of this money could be better spent in giving women options of choices about whether they want to live in safety or live in violence, about giving children a place to go heal or begin that healing process, and about giving more and more victims the ability to heal both financially, mentally, and physically. Thank you.
My concerns as a former retired judge is the fact of mandatory sentencing, or in other words, taking away the discretion the judge has in sentencing. I think one of the things you have to learn in a courtroom is that one size does not fit all in the sentencing structure. And when you have mandatory sentence, then there'll be, in my view, there'll probably be fewer pleas of guilty. There'll be more trials, of course. They'll probably be longer, and there may be more acquittals because the judge and probably the jury, the public, will be aware of the fact that the person has to go to jail no matter what. And so they'll be maybe acquitting far more people than they have in the past. But it's very difficult with the taking away the discretion.
Barry? Not much time left.
Okay, I'm going to be quick. I come at it from a different place. I was a judge in the Yukon. The blessing there is small community. I grew up with my handiwork of the justice system. And so I saw us take kids from families and saw them grow up in care, saw them grow up in the young offender facilities and become adult criminals. So it really proved to me that although we had a great team of justice officials working on these things, if we didn't have extensive community engagement, we were not going to be successful. My worry is that we're now going to spend a whole bunch of money on justice officials at the tail end of the system, and it's going to wipe out the funds for First Nations coming forward with their community-based ideas, that the community justice communities across this country and in the United States who are innovating new approaches. They're going to lose their ability to be effective and to make our community safe. You can't make community safe unless you engage the community.
I know we're sort of at our time limit here. We're glad to take any questions you might have.
Yes. Bruce Cheadlin with the Canadian Press. I've been following this for quite a while. You're not the first group that has made these types of submissions. The government seems pretty much impervious to your arguments. So it looks like this is going to go ahead. My question is, crime stats have been generally falling in Canada under what this government would call a soft on crime regime. But they've also been falling in the United States under a very tough on crime regime that they're now unraveling. So how do we measure success or failure? 5 years from now, what are we going to be looking at to say whether these measures, which appear to be coming in, are working or not?
Well, it's true that in North America there have been falling crime rates. A lot of that is due, I think, to demographics. There are fewer people in the age of active criminality, from 18 to 24. But our crime rate has been falling much longer than the American one. And we know the Americans are moving away from what has prevented them from keeping their numbers down, which is the mandatory penalties, particularly the drug mandatories. When I started practicing law in the mid-'70s, the total number of Americans in custody was something like 200,000. Today, it's 1.4 million people. Plus, you've got another 5 million who are customers of the system through probation or parole. It's all because of the mandatory minimums and the fear of crime that the American politicians have worked very well, and that Harper is trying to work here. I don't think he's sorry.
What do you envision the result of this regime be?
I think we'll have significantly more people in custody. I worry particularly about the Native people, and I think their numbers may be up even disproportionately. So now they're 22%, and at CSC they could be closer to 30, because their birth rate is so much higher than that of the general population. I think we're going to have more people in custody. There's going to be a bit of balance because of the problems that Justice Chadwick talked about in terms of people having their charges stayed or not getting acquittals in jury trials. But it's going to be a significant rise, I think.
You mentioned Aboriginal people. What impact do you see the bill having on the Gladue ruling and those principles?
Well, I think it can have a negative impact. Obviously, it already has. I'm going to ask Barry to get in here because his clientele was largely Aboriginal in the Yukon, of course. But I actually worked on the factum that we intervened in the Supreme Court of Canada on that. We got a tremendous judgment. And unfortunately, the follow-up has not been as tremendous in terms of courts taking the time to do Gladue reports, as they're called, that set out the particular circumstances of a young or not young Aboriginal person in terms of all the dysfunctions they suffer, the impact of residential schools and so on. But I'm afraid that there may be some temptation to even perhaps change the principles of sentencing that came in 1996 to make that less of a factor. I hope I'm wrong, but Barry, do you want to add anything?
Sure. I think the Gladue case was a very small step on a very long journey, and it wasn't a very effective step because they forgot to give the support to the justice system to do its work better through Gladue. But the best thing is not a whole bunch of justice people trying to figure out what happened in the community to create this kind of a crime wave or a particular offender. It's the community needs to come forward. And there's no money going to be in 5 years for that kind of stuff, because the first time that there's an austerity program, it's those new innovative things that are making a difference that are going to dry up in the funding. So from 5 years now, we're going to start having Aboriginal people coming back from long jail terms to their communities worse than we sent them off. I mean, if I thought for a moment, I'm a judge, I have to make my decisions on the best evidence. I haven't seen the best evidence for spending this incredible amount of money on something that we know doesn't work. So 5 years from now, we're going to have a lot of people coming back from crowded jails without being rehabilitated and coming back into the communities, and the communities are not going to want them because they're going to be worse than we sent them off. We need to figure out some way to change that.
So what specific evidence would you need to see to convince you?
Well, that putting people in jail for a long period of time actually makes them better people would be a good start. That spending more money on the justice system, which is armed with legal tools to solve social problems, would be a good thing. Just simple stuff like that. I mean, I think we spend more best evidence testing on what military plane we're going to buy than we do on this huge expenditure that's going to affect every community and every street. I'd like the same test applied to the justice system.
Do we still have time? Are there any other questions? If not, I want to give Don Bayne, Canadian Defence Council Association, a minute or two to speak to.
Maybe I can just speak to the first question, because the evidence is that other jurisdictions that have tried this more and longer incarceration are retreating from it. And it's not just the stories you hear from the US and in California and Texas, but those are good on the ground meters of where the rubber hits the road and it doesn't work. The tragedy here is this is proven failed policy. It fails as cost effective, so it's surprising for a conservative government. It's not evidence-based. In fact, it's contrary to the evidence, and it's proven to fail. You say that some stats are that there's a decline in the US, but if there's a decline where lack of non-recourse to incarceration, which is an expensive alternative, works as well or better, that's evidence in itself. What are we going to be doing 5 years from now? We'll probably be doing what Texas and California are doing and saying, filling the jails and then regurgitating these people into the streets is not smart crime policy. It's dumb crime policy at great public expense. And it doesn't create safer streets, it creates more lack of safety.
If we still have a bit of time, I want to mention sorry, did you have a?
Because yesterday, the former Quebec Justice Minister was at the Senate Legal Affairs Committee, and he made the comment that the idea that people will be spending longer time in prisons could be a good thing, because that means that then they'd have more opportunities to actually have programs and be forced into them to get out. So I thought I should just ask, I mean, how would you respond to that idea that actually the longer sentences may be helpful because then there's more time for rehabilitation and then eventually re-entry into the community?
Well, if I can begin on that, there's virtually no rehabilitation or programming at the provincial level. Certainly not for remanded offenders, as about, in some provinces, 60% of them are. The programming that goes on at CSC is pretty robust, I think, but a person who's serving a long sentence doesn't get to access that until towards the end of the sentence, the end of his parole and eligibility period. in any event. So they're not getting that kind of treatment in custody. The evidence is clear from criminologists that it's more effective to have treatment in the community. And the sociological, criminological evidence from Canadian criminologists like Paul Gendreau from the University of New Brunswick, they did a meta-analysis of over 1,100 different studies around the world. And they found for each year in jail, the evidence was that the likelihood of recidivism, of repeat offending, goes up by, I'm doing this from memory, but close to 2% a year. Prisons are not the place to treat people. And then, you know, as I said earlier, a lot of the people who need treatment in prisons are suffering from all sorts of mental health issues, substance abuse, and so on. And they're only being dealt with on the margins, effectively, in my view. Oh, sorry.
That question. Mark Belmer also was giving the suggestion that perhaps people who have been incarcerated should be responsible for paying for their own incarceration, whatever assets they have.
Well, I think that's kind of the mean-spirited populist view that he's expressing. I don't agree with that. These are poor people. I mean, you know, the reason they're in jail is they don't have enough money to live on. They don't have enough wits to live on. So you're picking on the vulnerable with that kind of attitude, and unfortunately that's all too prevalent. I wanted to take advantage of a few minutes left to talk a bit about what I think some of the shorter term solutions could be, and perhaps my judicial colleagues could expand on it. But I think that one of the big problems with mandatory sentencing in this country compared to other Western countries other than the US that have MMPs is there's no ability to do justice. There's no ability to depart from the mandatory minimum in appropriate circumstances. And we had that case in Ontario, Justice Malloy, so was that her name? Anma, pointing that out, where this, as she called him, stupid young man who got caught fooling around with a loaded gun, and he's going to get he would have got a 3-year minimum sentence, first offender. I mean, that is not justice as we know it in this country. And countries like Britain, Australia, most of the Australian states, South Africa, New Zealand have the ability to depart, where it would be unjust to impose the minimum penalty. The courts, if they give reasons, can sentence under the minimum. And that, I think that's what we need here. I think it would help the government, frankly, to show that people have the ability, as judges do, to, looking at all the circumstances of the offender and the offense, say this would just be wrong to send this young man to jail for 3 years. The other thing I think should be considered in the shorter term, assuming this thing goes through, because the impact on provinces is going to be so great fiscally, is to allow delayed or staged implementation of the elements of the bill. After all, this is a bill that should be 9 bills, and some are less controversial than others. There are some good things in the bill, but if we could deal with some of the ones that are more costly later, and so provinces can get ready, building, unfortunately, custodial facilities, then that would be a good thing. The third thing I think is, I hope the Senate considers recommending, is that there be a review. You know, it's often to have 3 or 5 year reviews of legislation. I think there certainly should be one here, and with a proper evaluation of whether it's working or not. I think most of us here have a pretty good idea of how it might work, but let's get the evidence. And that's what's been missing in this whole conversation. There's no evidence supporting the government's direction.
Which parts of the bill do you actually like and think the other ones should be delayed?
Well, you know, it's a big bill. There's things that are more technical in nature that, frankly, I don't know as much about. So I wouldn't want to point to anything in particular. I don't know whether any of you would, but you know, how many sections in the bill? 1,100 or so. There's bound to be something good, but I just can't point to it at the moment. Anyone else want to?
One more question. Sullivan, the government's heard these arguments ad nauseum, and as I said earlier, they seem impervious. Do you think that Vic Taves and Rob Nicholson actually don't believe this, or are they doing this for political purposes? Is this bill a political tool, or do they actually believe that this will work?
I mean, I think certainly when it comes to the victims, I think Minister Taves and Minister Nicholson have a very narrow view of what it is that victims actually need. And I think they equate victims' rights and victims' needs with how you deal with the offender. So if you just punish the offender enough, then victims will be happy. And certainly there are groups that support that principle. But the majority of people that I think are on the ground working with victims of crime realize that what happens in courtrooms really isn't going to help victims very much. The victims we know who turn to the court for justice are often very disappointed. In 5 years from now, our measure of satisfaction will be, are victims more satisfied with outcomes? I don't think that's going to be the case. I think everything this government does is political. It's ironic because in the long gun registry debate, evidence is important, right? The members at the Public Safety Committee wanted irrefutable evidence that this long gun registry somehow saved a life. But when it comes to evidence for the billions of dollars we're going to spend on this bill, somehow that's not necessary because they just have a gut feeling this is what works. To be frankly, I honestly believe that this is their ideology and they think this will work, and they just ignore anything that will question that. And I don't think that's a responsible government.
CTV News. How long, what's the lag time on this from implementation to when we see the effects of what this bill can do?
What do you think? Well, I think the initial question this morning about the 5 year, let's check it in 5 years. It generally does take almost that long to see, but I would say within the next 18 months or 2 years, we're going to see the increasing numbers in jail. Let me give you a recent example of that. The bill C-25 that dealt with the pre-sentencing custody credit was supposed to reduce the number of people in remand. It hasn't. It's gone up. It was supposed to increase and improve processing time in our criminal courts. It hasn't. I think in Toronto there's still an average of 13 or so adjournments in every criminal case where the person is pled not guilty. So you get some pretty early evidence of this sort of thing. And I haven't mentioned it, but I'm concerned about behavior within prisons. I think there's going to be, with the overcrowding and lack of hope, there's going to be increased violence in prisons. And it wasn't all that long ago, in the 70s, that we saw terrible riots in our federal penitentiaries. And who knows, I hope I'm wrong, but that could well happen again. And those will be pieces of evidence that this is so wrong-headed.
On that point about when we're going to see results, I mean, it would be really interesting, in my experience, to note that when the communities get involved, you can see the results right away. If we don't have the evidence and we're having this argument about, let's say it's not ideological, maybe not even saying that, but let's say it's not for the moment, then why don't we test it out? Why don't we see how a community partnership with the justice system, properly funded, does against a system that still believes in punishment only? Let's find out. I mean, we could find that out pretty quickly. And that ought to settle everybody's eggs about what should happen. Otherwise, we're like, well, if we were a medical facility and we were just doing the same punishment, the same remedy every time, where's that going to take us? So I'd like to see, let's test it. There are lots of communities that have already started partnerships. Let's see how they're doing against communities that don't have that community-based partnership.
Can I add one comment too to that last question? I can maybe say this and the judges might feel less comfortable doing it. An immediate response you're going to see is judicial and legal response to this. Constitutional challenges that these provisions breach fundamental justice. You've already seen a foreshadowing of it in Justice Malloy's judgment earlier this week or last week. And so protracted legal battles are going to start to unfold over this unjustified policy.
Thanks for coming.
Yes, sir. Thank you.
Don't be discouraged. Thanks for the time that you spent on this issue.